Hello and welcome to the session in which we will discuss the General Data Protection Regulation, which is known as the GDPR. It's basically a data protection and privacy regulation that was implemented in the European Union zone, the EU. So hold on a second. If this is in the European Union zone, why do I have to learn about this if I'm taking the US CPA exam? Well, why? Because there are certain companies that might be affected through this GDPR. Therefore, as an auditor, you need to be familiar in case you are engaged in a compliance engagement or in case you are performing the audit, you need to be aware of the privacy laws. And this GDPR introduced significant enhancement to data protection and privacy laws in the EU. However, those privacy laws might affect US as well as other companies other than the US. In this session, we would look at the key provisions as well as the 6 principles of the GDPR. Let's go ahead and get started. Before we proceed any further, I have a public announcement about my company, farhatlectures.com.
Farhat Accounting Lectures is a supplemental educational tool that's going to help you with your CPA exam preparation as well as your accounting courses. My CPA material is aligned with your CPA review course such as Becker, Roger, Wiley, Gleam, Miles. My accounting courses are aligned with your accounting courses, broken down by chapter and topics. My resources consist of lectures, multiple choice questions, true-false questions, as well as exercises. Go ahead, start your free trial today.
First, we will discuss the key provisions of the GDPR. And first, we have to know that the GDPR grant individuals, which are referred to as data subject. It means you and I, especially if you live in the European zone, various rights concerning their personal data, including the right to access, rectify, erase, restrict the processing of their data. So simply put, it gives the individual the right to data portability and the right to object to certain type of processing. It gives you the right to do so. Also, it gives you the consent right, which is the organization must obtain clear and affirmative consent from this individual, from the subject right, from you and I, before processing their personal information. So consent should be freely given. In other words, you're not tricking me into giving this consent. Specific, exactly what are you looking for? You need to let me know how you're going to be using this information, and I can easily opt out if I choose to. I can change my mind, and you have to listen to my decision. Organization some organization will have to have data protection officers or DPOs responsible for ensuring compliance with GDPR within the organization. If you're large enough, you need to have someone, and there's a lot of jobs for this, basically making sure you are in compliance with the GDPR. You are called data protection officer. Also, in case there was a breach, data breach notification, it mandates the notification of data breach to relevant supervisory authority, and in certain cases to the affected individual data subject within a specific time frame. Very similar to HIPAA. Basically, both of them are the same. HIPAA and GDPR, those are privacy laws. Other key provisions is accountability and governance. Organizations are required to do what? Implement appropriate technical and organizational measure to ensure the protection of the personal data. Make sure your information is protected behind a firewall. Not anyone can access it. They also must maintain records of data of processing activities. And if someone wants to look to see what happened, they can go back and look at it. Also, it covers international data transfer. It imposes restriction on the transfer of personal data outside of the European Economic Area to countries without adequate data protection regulation. So if you're transferring this data, it's going to impose some restriction on that if where you are transferring the data does not have data protection regulation. You also have to have data protection impact assessment. You are required to basically assess the high-risk data processing activities to assess and mitigate potential risks. Simply put, you have to kind of basically not guess, but basically try to formulate where could the risk lies here and try to deal with that risk. Also, it has a teeth. What does that mean? You could be subject to a penalties. It includes severe penalties for non-compliance, including fines up to 20 million euros or 4% of the company global annual turnover, whichever is higher. So where does the GDPR applies? Of course, it's going to apply in the EU zone, but is this the only place where it applies? Not necessary. So data processors located within the EU, well, obviously, even if the data processing occur outside of the EU, as long as it's an EU company, it is subject to the GDPR. Also, data processors outside the EU who offer goods and services, for example, a US company is offering goods and services within the EU. Just think of Coca-Cola. Just as a simple example, they sell that product in the EU, they're subject to this. Or if these companies monitor the behavior of the EU residents, simply put, collect data for various purposes, for business purposes. Also, data processors outside the EU subject to the EU law through public international relation. Simply put, you are located in an area where the EU law is in effect through international law, then the GDPR will apply. There are 6 principles to the GDPR. We're going to go over them, make sure you know them. The GDPR is built upon 6 fundamental principles that guide the handling of personal data. The first principle is lawfulness, fairness, and transparency. When you're processing personal data, it must be lawful. You brought the permission, meaning it must be legitimate. You have the permission, and you have the consent or the contractual necessity, the legal obligation to be able to do so. Lawful. It must also be fair to the individual. The data should inform about how their data will be used in a clear and transparent manner. For example, if a company obtain explicit consent, must obtain explicit consent from its customer before sending marketing emails. The consent requests clearly state the purpose. Why am I asking you for this? Marketing communication, and customers are informed about the right to opt out at any time. So when you sign up for a service, oftentimes they ask you, would you like to receive marketing promotion discount? And you have to check the box. And basically they're getting your consent. But also after you check the box, if you decided to opt out, when they send you those emails, you should be able to do so. Another principle is purpose limitation. Simply put, the personal data should be collected for specified, explicit, and legitimate purpose. Tell me exactly why are you doing this? And it should not be further processed in a manner incompatible with these purposes. So whatever you collected originally for that purpose, you have to use it only for that purpose. So a good organization should clearly define and communicate the purpose. Why am I collecting this? Okay, for example, an online retailer collect customer data, for example, name, addresses, email, for the purpose of processing, delivering orders. That's the purpose. That's why you are giving me this information. You cannot take it and sell it to a third party or use it as a marketing tool. Data minimization. In the prior slide, we looked at what? Purpose of limitation. Collect the data for that specific purpose and only collect the data necessary. Don't collect any additional data that's not necessary. Organizations should only collect and process personal data that is necessary for the purpose. You remember there's a purpose limitation, but collect only that data. That's called data minimization. The data should be relevant, adequate, and limited to what is necessary for that particular purpose. Unnecessary or excessive data is discouraged. For example, medical clinics collect patient information for appointments. Instead of asking for extensive personal detail, they only request necessary information such as name, contact, and medical history relevant to that specific appointment. Accuracy. The personal data that you collected must be accurate and kept up to date. You should take reasonable steps to ensure that inaccurate data is corrected or erased as an organization. Individuals also have the right to request what? The correction of inaccurate data concerning them. For example, a bank update customer contact information to make sure the address and phone numbers are accurate. When the customer informs the bank should update that information. Also, one of the principles is storage limitation. Personal data should be kept in a form that permit identification of individual for no longer than necessary for which it was collected. So you cannot keep it forever. The principle is often linked to specific retention period based on legal requirement or the organization purpose. You cannot keep my information forever. Once you don't need it, get rid of it. Properly, of course. Example, an HR department retain employee records for a specific period, as required by the labor law, and deletes them within the retention once the retention period expires. They don't keep them forever. Also, the data that they collected must be secure, of course, integrity and confidentiality. So the organization are what? Responsible for ensuring the security, integrity, and confidentiality of this information. They must implement appropriate technical measures to do what? To protect against the breaches. We talked about breaches, unauthorized access, alteration, or disclosure of data, and we'll talk about protection later on in various protection methods of the data. For example, a cybersecurity firm employs strong encryption. That's one way to protect the data, to protect sensitive customer data stored on its server. So if someone accesses the data, they can't even read it. Access control also are in place. Only authorized people can view the information. Unauthorized people, they cannot view or modify the data. What else do we need to know about privacy laws? There's something called the Privacy Shield. Now, the Privacy Shield is gone, but we need to know a little bit more about it. We'll spend a minute or two. The Privacy Shield, also known as the EU-US Privacy Shield, was a framework that allowed for the transfer of personal data between the EU and the US. Now, it was established to bridge the gap between the EU data protection laws and the US protection laws. The EU protection laws are a little bit more strict. And basically, this privacy shield will have similar key provision to the GDPR. I'm not going to go over them. Notice, choice, accountability, security, data integrity, access, recourse, enforcement, and liability. Very similar to the GDPR. But what happened to this privacy laws, to this privacy shield, it faced criticism and legal challenges, especially in the European Court of Justice, because they felt it did not go enough to protect EU residents. So in July 2020, the ECU, the European Court of Justice, invalidated this privacy shield because it did not provide sufficient safeguard for the protection of European citizen data transferred to the United States. So the decision basically says it's ending this privacy shield as a mechanism for transferring data. So what should organization do? The organization that previously relied on this privacy shield to transfer data, so they have to find alternative mechanism. And what they do now, basically, they include standard contractual clauses, basically specific contract between the two parties or binding corporate rules to establish legal safeguards for data transfers. Let's take a look at a multiple choice questions from Farhat lecture, just to kind of understand the material, because on the CPA exam, you're expected to do what? Answer multiple choice questions. In which scenario does GDPR apply? So you have a bunch of scenarios, and we have to decide in which scenario does it apply. Okay, let's look at D. Only when data is processed by EU-based organization? Not necessary. It doesn't have to be EU-based organization. It could be a US organization selling their product in Europe. GDPR will apply. So D is out. Let's look at C. When data processors are not subject to EU law through public international law. No, it does. It does apply under those circumstances. A good example will be an embassy. If you're working in an embassy, which is basically if it's an EU embassy, that's EU territory. So it does apply under those circumstances. C is out, so we are between A and B. Let's look at A first. Only when data is processed within the EU. No, it doesn't only have to be processed within the EU. A is out. When data processor offer goods and services to EU individuals. Yes, if you offer goods and services to EU individuals, you are subject to the GDPR. You could be located in Montana and selling services to the EU. You're subject to the GDPR. For example, my company, Farhat Lectures, I have to have a disclosure about this because I do sell my subscription in the EU zone, therefore I'm subject to that. What should you do now? You should go to Farhat Lectures and look at additional MCQs. That's going to do what? That's going to help you prepare better for the CPA exam. The CPA exam is 20, 30, 40 year investment in yourself, in your career. Take it seriously, invest the time. Good luck, study hard, and of course, stay safe.